Yeah, Assalamualaikum and good afternoon, students.
Good afternoon, madam.
Afternoon, madam.
Yeah,
Good
okay.
afternoon, Doctor.
Waalaikumsalam, madam.
Waalaikumsalam. Okay, students. For today's class, I will teach you on misconduct of employee. Yeah, okay. I noticed that there are few students who send me to check with the issues for the assignment one. Okay, so please make sure that you know which topic you are going to do your assignment one. Because I see some of the issues are not related to the topic. Okay, so you must know which topic you will be tested. Even for the mid exam, if you put something outside the scope of the examination, you will not be given marks, and the answer can be wrong answer. Okay, so for the assignment, okay, make sure that you know which topic you will be tested, and then you will know what will be the answer be. Because you have to give the relevant cases according to the topic. Okay, understood? Okay, so for the assignment 2, I already posted last night. Okay, the topic for the assignment 2. For assignment 2, there are 2 cases. Okay, two question. Okay, quite long question. So when you distribute your work among your friends, you must remember that you got 2 more 40% assignment coming soon. I think after the mid break. Okay, because after that your time will be very short. Okay, you have to complete immediately within the syllabus. Okay, and then submit. I think that will be like somewhere in January also. Okay, so for the second assignment is 7th of January. Okay, and the third assignment, which is 40%, will be in January also. Okay. So, what is misconduct? Okay, maybe when you search cases, you already come through few cases which is related to misconduct of employee. Okay, so can someone give me example of misconduct? Bawazir, are you there? Okay, we got answer from Surita. Stealing, okay, is a type of misconduct. Okay, that means you, as an employee, you cannot steal any property that belongs to the company. Okay, Arisa Surita. Okay, then other example, any other example of misconduct at workplace? Bribe, okay, so giving bribe is also prohibited. It can be a criminal offence. Okay, so let us see further this topic. What is the definition of misconduct? Okay, so there's no we got answer from Bawazir. It's cheating. Okay, it's also a kind of misconduct. Okay, thank you for all those who gave me the answer. Okay, misconduct. So there's no definition in the Employment Act. Okay, so there's misconduct and discipline is related because once there's a misconduct, okay, the employee have to undergo a disciplinary action. Okay, so normally the employer has right to determine the rules and regulation and also procedures at the workplace and what amounts to misconduct. So sometimes it is related to the kind of job, like cashier. You cannot take what you call money from the cash box. Okay, and you cannot also like steal. Okay, like those who are working at the government office, you are prohibited from taking bribery, okay, because that is like big common, okay. So you have to be careful, okay. What is misconduct? So the definition of misconduct is also make into the regulation. That means is incorporated in the into the regulation at the workplace. Okay, so normally the employer will set the regulation. Okay, what is misconduct and what happened if you have committed misconduct at workplace? What is the procedure, okay, to be taken against the employee? Okay, so since there's a no definition, we have to refer to the case law. Okay, so we got one case law, Plat Rubber Sindra Berhad, okay, versus Go Chok Guan. This is 1985 case where the court says that the employee is vested certain obligation. Okay, so the employee are given obligation that arising from the employment contract. So any breach of duty may amount to misconduct. So if you do not follow your duty, you do not comply with the duty, that can amount to misconduct. Okay, so the misconduct must have some relation with the duties. Okay, in the same way, if an employee is guilty of such a crime outside his service, that means something which is not related to his employment contract, okay, but it makes it unsafe for the employer to keep him at the workplace, then the employee may be dismissed. So the misconduct can be something that related to the employment contract, or it can be something to do with the duties, and it can be something that also which is happen outside the working place, okay, outside the employment place or his service, okay. But if the employer find that it's unsafe for the employee to be there, the employer can dismiss him, okay. So let's say employee is involved in bribery, okay, or stealing, so it can be unsafe, okay, for the employer, or something which has happened outside, like the employee had quarrel with someone, okay, outside, okay, and maybe the police was at the scene and his photo was published in the newspaper, so the employer came to know about that, so it can be something that is a crime outside his service. Okay, so I think the explanation regarding the what amount to misconduct, okay, and what is misconduct, okay, has been well explained in Platt's case. Okay, so this case also further says that any infringement and regulation, um, I'm sorry, I forgot to off. Okay, any infringement of rules, okay, and regulation would constitute misconduct. So as long as it can be shown that the rule is reasonably necessary for the effective and also efficient management of the employee. Okay, so if you can show that the rules that set by the employer is necessary for the efficiency of the management, okay, so if there's any breach, it can be a misconduct. Okay, as simple as lateness. If you are always late to work, okay, um, every week there can be like 1 or 2 days you are absent, okay, so in total 1 month it can be like roughly about 8 days or 7 days you are late. So lateness is also a misconduct. Okay, smoking, okay, smoking, now there's some rules okay, imposed by the government, the area that you can smoke, so smoking can be an offense and misconduct, and in some critical area you are not to you are prohibited from smoking, okay, gambling, okay, some I mean, there are some employees like to gamble during lunchtime. Can be very simple that maybe by using card or any other source. Okay, then as serious as fighting, theft, and dishonesty. Okay, so these are some example, and we also will see some example later. Okay, with case law. Okay, so the obligation to also arise from implicit term in the employer-employee relationship. Okay, so some are very what do you call um, um, very serious. Okay, that is misconduct. Okay, and it's very well known to anyone, any employee. Okay, if you gamble or you fight or you do any theft at the workplace, it is a misconduct. Okay, but those who are implicit, that means is implied in the term, in the employment relationship, as such as to act with reasonable care, can be also a misconduct if you breach the duty. Okay, so the duties can be from the rules, okay, which we can say that is express, and it can be also implied duty. Okay, if you breach those duty, okay, it can constitute to misconduct. Okay, so we have seen from the case, okay, and then there's also another case which explain misconduct. Okay, so misconduct is improper behavior. Okay, something to do with your behavior. Okay, intentional wrongdoing. You are doing something wrong with intention, or it can be deliberate violation of a duty. Deliberate violation of a rule. That means the rule set by the employer, you have breached the rule. Okay, so as relates to employment relationship, it means any conduct inconsistent with the faithful discharge of the duties or any breach of any express or implied term. Okay, so when it relates to employer, it is something that you have breached the duty, okay, or faithful, or it can be something to do with breach of duty of express or implied. Okay. Okay, so you have seen the definition, and because it can be so many kinds of act that can constitute misconduct. So it can be from the employment relationship, from the rules, from the duties, implied and express duty. Okay, so what happen if employee commit misconduct? Okay, so here, okay, section 14(1) of Employment Act. Okay, so you must know which act to apply. Okay, so this act says that an employer may, on the ground of misconduct, so you have known what is misconduct now, you have understood. Okay, so this misconduct is inconsistent with the express or implied condition of service. Okay, so only after due inquiry. So the employer can or may, on the ground of misconduct, okay, and also after due inquiry, okay, take the following action. Okay, that is to dismiss without notice. Okay, so the employer, when he came to know the employee have committed stealing or bribery at the workplace, he can dismiss without notice, or he can downgrade the employee. Downgrade is to give a less um, salary and position. Okay, or impose any other punishment as just and fit, and where the punishment of suspension without wages is imposed, it may not exceed 2 weeks. Okay, so in this section, you can will know that the punishment for misconduct is 3 things: dismiss, downgrade, impose any other punishment. So if you do not want to dismiss, you do not want to downgrade, sometimes the misconduct is not very serious, like coming too late. So you give warning or you downgrade the employee. Okay. So you can, it's up to the employer. Okay. And if the employer choose to suspend the wages, okay, suspend without wages, cannot be more than 2 weeks because the employee have to live, have to survive, so he should get at least 2 weeks salary because the 2 weeks salary is already suspended. Okay, so this can be taken after, what is that? After what?
After
Yes.
misconduct.
Yes, after? What was it?
After misconduct.
After? Due?
Misconduct.
Can't hear you.
Inquiry.
Yeah, after due inquiry. Okay. So what is due inquiry? We will learn later towards the end. Okay. So it's very important. There are so many cases where the employer forget that they can take action, but they do not follow the procedure. Okay, when procedure is not fulfilled, okay, they can be sued and they have to pay compensation to the employee. Okay, so when you are at the management or you are HR officer, you must remember that you can take action against the employee, but you have to conduct a proper inquiry. Okay. So subsection 2 says that employer may suspend the employee. That which I mentioned earlier is the punishment, but now it's about the suspension of the employee from work. Okay, so the employer can suspend the employee from work for a period of 2 weeks also. Okay, he can suspend for 2 weeks. Okay, but he should pay at least 2 weeks. He should pay at least half of his salary. Okay, half is same as 2 weeks. Okay, that means for 1 month you got 4 weeks, so half of his salary for the month, okay, will be 2 weeks also. Okay, that means why employer want to suspend the employee from work? Can anyone give me the reason? Why in certain cases the employer he may want, even though there's a law, some employer do not want to suspend, some employer says that it's good to suspend the employee from work. Why? Any idea? Or between the other employee, maybe if the other employee harass him. Okay, any other term that you can use? Why you don't want the employee to be at the workplace, the employee that have conducted misconduct? Why? Or committed? No, it's not absent. Okay. Why you don't want the employee to be at the workplace? An employer do not want to see the employee's face. Like say, I don't want to see him for 2 weeks. Why? Any reason? No, not cheating. Cheating is like
It affect people.
is misconduct. Yes.
Maybe his presence may have effect on the morals of worker.
Maybe his presence will his presence will affect the you mean the work, the relationship with the other
Yes,
employee.
create those pressure and tension.
Maybe, okay. And what is important is that now during the 2 period where the employee is suspended, the employer can do investigation, okay, and also to prohibit the employee from stealing any data or evidence. You know, sometimes everything is in the computer. The employee comes and want to erase everything, want to delete all the information. Okay, sometimes he do, like, let's say he cheat with the bank. Okay, he has stolen or already have transferred money into other accounts. Okay, so if you allow the employer to be at the workplace, okay, even though you can access anywhere the computer, but some of the data is kept at the office. Okay, so that will save all the evidence. Okay, so we got cases where employee knows that he's going to be suspended, he has stolen something, he will come and erase all the evidence. Okay, so the law give the employer 2 weeks. You can suspend, the employee from working, and you only need to give him 2 weeks. salary. Okay, the suspension is also only for 2 weeks. You cannot suspend for more than 2 weeks. Okay, you can say that, okay, you go back, we want to do the investigation, you go and rest. Okay, you don't have to work only for 2 weeks. Okay, that means you must carry out the investigation very fast. Okay, so if the inquiry here, okay, suspension until finish the investigation. Yeah, it's only 2 weeks. You can suspend, maybe if you can do the investigation 1 week. So 1 week is enough, because the 2 weeks here is the maximum period. Okay, so if the inquiry, yeah, okay, you already suspend, okay, and you want to investigate, okay, does not disclose any misconduct on the part of the employee. Okay, so now you have to pay him, even though he did not come to work, because you suspend him, you have to pay him the full wages, because the inquiry or the investigation does not show that he have committed misconduct. Okay, so sometimes this is just like complain about the employee, but when you investigate, actually there's nothing. Okay, so the employer now, because he suspend, he have to pay him the wages that suspend. If 1 week suspend, 1 week wages lah, because he only did not come work 1 week. You suspend 2 weeks, 2 weeks wages should be paid back to him. Okay, so understood, subsection 1, when to use, and subsection 2, when to use. Okay, now the burden. Who have the burden? I think common sense shows that the employer should have the burden, because he is the one who want to take action against the employee, because the employee committed misconduct. Okay, so now a person is like assumed to be innocent until he's proven to be wrong. Okay, so the burden is on the employer. Okay, so you cannot assume a person has committed. If let's say there's a CCTV, okay, 2-3 CCTV capture shows that he have done misconduct, so that is not enough. Okay, you must not act on assumption. You must have the real facts with evidence. Okay, and in case of misconduct, which is criminal, criminal like stealing, bribery. What else can be criminal misconduct? What else can be criminal misconduct? Students, can you give me examples of criminal misconduct or criminal offence at workplace?
Is the power abuse considered one?
Power abuse. You must have under what? Maybe you have what do you call, some rules at the workplace says that you can withdraw, maybe as a director you can withdraw 50,000, or you can sign a check which is limited to 10,000. Okay, so if there's any regulation on that, you can you can what do you call, you can say there's a what do you call, that you have limit your power. Okay, you have done something that over what has been given under the certain particular rules at the workplace. Okay, but for that you have to show that there's some rules that allow you to do certain things, but you already exceed the limit of the rules. Okay, any other criminal? For the criminal offence, it'd be like stealing, okay, fighting, okay, taking bribe, harassment, fraud. Okay, so Farah and the others are giving example. Okay, so you got the idea. Okay, so for that, even though criminal, criminal offence, the burden is heavy, but for the employer-employee relationship, the employer need to satisfy that at the time of dismissal, there's a reasonable ground for believing the offence put against the employee was committed. Not very heavy, a reasonable grounds. If you can show that the employer have committed, that's enough. The employer can take action for misconduct against the employee. Okay, but if you want to save what you do, normally for criminal offence, you report to the police. Police will take away the employee, okay, and let the police handle the case. Okay, so if you do, until the case is with the evidence, the police will investigate and do all things. Okay, the employee would not be at the workplace. Okay, so another case here. Okay, rasa sayang case. The employer have to prove the misconduct alleged by the employee. So in the case here, the court agrees with the union. There's no denying right of the employer to punish, but there is also the right of the employee not to be punished if there is no offence. Okay, so you must be very careful if there's any misconduct before the hotel can show that the punishment does fit the crime. It must first show the crime. Okay. So if you want to punish an employee, you must first prove the employee has committed a crime. Okay. Okay. So that's about criminal cases. So if you want to be safe, you hand over the employee to the police. Okay. So have you heard about condonation? Okay, so this is something new. If you learn or you read Danza Aidurai, you will know about this. Okay, so condonation is where an employee has committed an offence at the workplace or committed a misconduct, but you still allow him to work. Okay, so it doesn't matter, as you've seen just now, stealing, coming to work late, taking bribe, or maybe has breached the duty of fidelity or faithfulness. Okay, so you don't care as an employer, you don't care, or maybe the employer is a top management, they don't have the time, the directors have no time to watch the employee, but they have the HR department, they have the supervisor are not interested to take action. Okay, so you are assumed to have forgive the employee. Okay, so the forgiveness is from the part of the employer. Okay, so this case, English case says that Merrick versus Sterling Brothers Limited, this BROS is Brothers Limited, had that although when a master is the employer, finds himself entitled to dismiss a servant, the employee, for misconduct, he should exercise his right within a reasonable time. That means the employer must act immediately. You cannot wait 3 months, 6 months, 1 year to take action against the employee who have committed misconduct. Okay, so you have to act fast. And we got also our Malaysian case for that. UTC or United Traction Company Berhad and Transport Workers Union. So this case says that condonation is a permission granted to an employee to cover a prior misconduct or breach of duty. It would only apply in situation where the employer allowed the employee to continue his employment after the misconduct. So condonation is where you allow the employees to stay in the office, continue his work after you have known or discovered the misconduct. Okay, so it's actually the employer's decision to take action against the employee who have committed misconduct. So if the employer just ignore, okay, he is assumed to have forgive the employee. Okay, so forgiveness also apply in employer and employee relationship. Okay, now we look at the type or the aspects of misconduct. Okay, because misconduct is something that it can happen once in a lifetime of an employee, and some employee like to repeat and repeat even though you give warning. So what is the legal effect? Actually, this is something that more that we teach to the law student, but it's good to know, okay, about the aspects of misconduct. Okay, so if it's a single misconduct, in any misconduct, even the criminal offence, if you steal one time, a public prosecutor will say that you have only one criminal record. If you got many record, you say that you got many records, so your punishment will be heavier. Okay, so the principle also applies here. Okay, and we got our Malaysian case. Transport Workers Union case says that a single act of misconduct may justify a misconduct only where the misconduct is such that it goes to the root of the contractual relation so as to indicate the unwillingness on the part of the employee to be bound upon his original terms of the contract. Okay, so here, even though one misconduct, but this misconduct must be very serious, the employer can justify to dismiss because it indicates unwillingness on the part of the employee not to be bound the original term of the contract. Okay, you are an accountant, maybe. Okay, example. So you have um, duty, saying that you must be implied duty, okay, to be faithful, okay, to your employer. Okay, so if you done one misconduct, okay, that goes to the root of the contract, so the employer can dismiss you. Okay, where you forge signature, maybe, okay, forge the signature of the director, okay, so only one misconduct enough, the employer can dismiss you. Okay, so it must be very serious misconduct. Okay, so understood, single misconduct, only one misconduct. Can you all understand what is single misconduct? Can, okay, Hara. Okay, Azin, Alisha, okay. So we got similar. Similar means same, also apply to the criminal law also. Okay, if you always steal, so the court will look at your habit. Okay, you like to steal, so the punishment must be heavier also because it will punishment which is heavy punishment will deter you from stealing. Okay, so under the employment relationship, PA Neto's case says that the fact that the person have committed similar misconduct before, although admissible, that means it is accepted for punishment purpose, but should not prejudicial to show disposition of person's mind. Okay, so you cannot prejudice against that person. So law is very lenient here, even though you know the person committed more than one misconduct. Okay, so you cannot be prejudiced to the person. Okay, but that person means the employee cannot say that he have done by mistake or by accident. Okay, so here the court will decide. Okay, even though similar misconduct, few times you repeat, or maybe as like going to work late. Okay, so the employer, okay, you cannot say that, okay, I'm late because um you know you want to rebut. Rebut means you want to protect yourself, to defend yourself by giving some excuse. You cannot because you are repeating the same mistakes, okay, the same misconduct. Okay, so the court here is very lenient. Okay, so you cannot be prejudiced against the person, the employee, and the employee also cannot say that there was a mistake or there was an accident. Okay, and past misconduct. Okay, so past means everyone knows, I think. Past is something already past. Okay, past misconduct. That means if there's any past fault under Syarikat Great Eastern's case, says that even though it's relevant in time and nature, Okay, sometimes the past is something that you have to take as what do you call um, um, what do you call it? It can be like something for you, a lesson for you. Okay, so it is relevant in time and nature, but cannot be taken into consideration unless and until a fresh is committed. Okay, so even though maybe at past you got one misconduct, okay, it was past, that means with a previous employer, and when you join a new employment, the new employer cannot take into consideration unless you have committed one the same crime or whatever crime with him, okay, in his working place. Okay, because sometimes when there's a past fault that we have done, we take it as a lesson and we improve. Okay, so that's the idea here. Okay, another case, Mas and Kadir, Mas and Kadir bin M. Zalman's case says that past misconduct past misconduct could be considered to be a cumulative effect in deciding the punishment. So, if you have done past misconduct with the previous employer, let's say you have steal and he have a record, and when you join a new employment and there's also the same record that you have stole or you have done some misconduct, so the employer can give you a heavy punishment because it is a cumulative effect. There's a cumulative effect in deciding the punishment. Okay, is everyone listening? Yes. Yeah.
Yes, madam.
Okay, thank you. So criminal misconduct. Then we have heard about this. Okay. So if it's a criminal misconduct, the employer must fully justify the execution. He cannot merely be suspicious. Okay. However strong the suspicious may be, the proper way is either to report the matter to the police or to hold a domestic inquiry. Okay, so if you're suspicious, not enough. You think money been missing every time in the office, so you are very suspicious. Cannot. You must have some accusation. That means you must have somebody to accuse, and you must have evidence. So, uh, the proper way is either you report to the police, let the police handle, or you as an employer, you must have or conduct domestic inquiry. Okay, so by doing so, it will give the employee opportunity to rebut the accusation, and the court says that in this manner the natural justice is served. That means natural justice is given to the employee. Okay, so it's a good uh, word. I mean, the judgment is very well written. Okay. Okay, so there's another case that support the criminal misconduct. Okay, so the Transport Workers Union's case says that it's not necessary for the employer to wait for the prosecution of criminal proceeding, because criminal proceeding takes years to complete. Okay, so the the employee is dismissed by the employer for misconduct after doing inquiry. So if the employer, let's say, have done domestic inquiry and he have dismissed the employee because the domestic inquiry shows that he have committed a criminal misconduct, so the employer have no obligation to take back the employee if the criminal proceeding have acquitted him as already acquitted. That means he is not found guilty in the criminal proceeding. So the employer have no obligation to take him to work, because on his part as an employer he have done the domestic inquiry, and the domestic inquiry shows that the employee has committed misconduct. Okay, so is it clear, as an employer, if you are facing a criminal misconduct, what you should do? Can you understand this part? Okay, you have to conduct domestic inquiry. That's enough. Okay. Now, if there's some misconduct outside the employment, okay, you say that it's a private conduct, it's my business, why the employer must, what do you call, interfere, okay? So this is a old case actually, 1975, Subramaniam Sara Tambal case says, because if it is a case that involve those who are at the plantation, okay, they normally sell liquor. The liquor means like samsu, for those Malay students, maybe samsu or liquor. Okay, they make liquor by themselves. Okay, the liquor is that they make from paddy, they make from some leaves, okay, or maybe they can make leaf from the coconut water, okay. So when they drink this, they are drunk, okay. So sometimes there are some workers who do this business, okay, and sell it to the employees or workers, okay. So in this case, says that the employee's private conduct, okay, is a proper consent of his employer, okay. When some legitimate interest of the employer is injured, okay. So you must see whether the employee is affected or not with the private conduct of the employee. Okay, so if the employee is affected, okay, so there's a misconduct, the employer can take action for misconduct. Okay, that means you have to go for the domestic inquiry. Okay, so it's even the private misconduct. Okay, and we got also one case where the employee has involved in kawat. Okay, so the company, okay, says that um, the act of the employee is um, grave enough to ruin the image of the company, because the company here is in a small town. Okay, so the employee can be dismissed. Okay, so this is the last time. Provocation. Okay, I think I have explained earlier, where the employees sometimes they are in large number. Sometimes they can be provoked by another person, okay, at the workplace. Okay, so Sungai Chino Estates case says that in this case, Nair is the employee. Okay, he was provoked by the manager. Okay, so the manager provoked him, and then he have I think fight with the manager. So the court says that okay, the company can punish Nair, okay, but not to dismiss him, because the manager is the one who have provoked him. Okay, so there's a provocation. So you provoke the employee, and then the employee get angry, and then the employee have done something to you. Okay, so the court says that in this case, you cannot punish him, you cannot dismiss him. Okay, dismiss is to terminate the employee. You cannot do so because the fight started with the employer, the manager's act, okay, that provoked the employee. Okay, so those are the types of the misconduct. Okay, so we got single, we got similar, we got criminal, we got private, we got provocation. Okay, so those are the types of misconduct. Okay, so any question? This is something that
No, madam.
okay, you can actually. I'm not sure your slides have this. Actually, you can delete this. This is regarding the what you call condonation. I think at the wrong place. Okay. Okay. So we got few types of misconduct. Okay. Um, like insubordination, disobedience, lateness, absent, gambling, theft, dishonesty, cheating, fraud, duty of fidelity, and fighting. Okay, so is it possible if I ask you all to rate this partner kinds of misconduct by yourself? Is it possible that you can read from the case yourself, or you want me to explain? Any student you want me to explain?
Doctor,
Yes.
can you explain the first one?
Which one?
First one.
Yeah.
Insubordination.
Okay, I see. This is some kind of misconduct, but according to my slides, I did not go every topic here. Okay. Let me see. I have leave. Insubordination is that you have somebody that above you, okay, but you do not follow his instruction. Okay, so those are the examples, but I don't have a case here, and I think it's in the textbook. Okay, insubordination is that you you got a superior, okay, person, but you do not obey the instruction. You can say that is you are disobedient to your employer. Okay, did you get me? Was it?
Yes, doctor. So the first one and the same with the disobedience, right?
Yes. Yes.
Is it the same with the disobedience?
Yeah, it's the same. That means you do not follow the instruction of the employer. Okay, you are disobedient. You are insubordination with him. That means you do not follow the instruction. You are not a faith. It's not faithful. You do not obey the instruction. You are disobedient with him. Okay, I'm not sure in the textbook there are cases on this. If I could find, then I will put in the online. Then okay, is it okay? I call you Ahmad or Bawaze?
Oh, zero. Okay.
Bawaze, okay, okay. So there are cases like few cases here, lateness. Okay. So can you go to work late? Some company are very particular and they have their punch, a card, and also thumbprint. Okay. So we got one case here, Hong Wong Holdings case. This case says that coming to work habitually was a good ground for dismissal. If you're always late, every day late, habitually, that means your habit. Okay, so it can be a good ground for the dismissal. Okay. Another case, the Saudagar Belian's case says that leaving the work earlier without permission is treated more serious than the act of late coming. Another case give the opinion you cannot leave the your workplace earlier without permission. Okay, the reason is that an employee may come late on variety of reason. Okay, sometimes the car get punctured, or maybe he was late for any other reason like traffic jam. But after joining the work, there can be little excuse for leaving the workplace earlier without permission. So you cannot leave the workplace earlier without the permission of your employer. Okay. Then absent, for absent, I think you already known from section 15. Okay, the same section can apply. It's under the statutory provision, section 15.2, section 13.2, and 60. All these under the terms and condition of employment. Okay, and there's a case for section 15 also. If you are absent for more than 2 days, it must be more than 2 days, and you do not have any reasonable reason for that, why you are absent. And if you got an MC, you fail to inform the employer. Okay, and leave, you cannot be absent without taking leave, like annual leave like that. Okay, so the leave must be approved by the employer. Okay, the leave is a permission. Okay, it must be granted. Okay, and we got also assault and fighting. There's a provision under the penal code. It's an offence under the penal code. And fighting is also a serious breach of discipline, where the employee can be dismissed, straight away dismissed. Okay, but it must be with what you call domestic inquiry. Okay, and if you this is for which one? Okay, where you use filthy word, you do not use proper word at the workplace, okay, a vulgar word against the superior is also a serious misconduct. Okay, so you must watch your word when you speak to the colleague at the workplace, or maybe your supervisor. Okay, so you cannot shout at them. Okay, and you must use a proper um, um, language or proper words. Okay, then intoxication also explained now, where there's a one case that you cannot be drunk at the workplace, but you must have evidence. Okay, so in this case there was no evidence. Okay, you cannot punish an employee for drunkenness without any evidence from the doctor. Okay, and regarding skill and care, okay, the employee must do the work with care, with due care or with skill. Okay, so like the driver, you must make sure that the vehicle is in a proper condition. But in this case, the court give the evidence that there was a mechanical defect on the express bus. So um, the um, the company also cannot prove that the employee was negligent. Okay, so the dismissal was unfair. Okay, and breach of duty of fidelity. Okay, the earlier case or this case can be used. Okay, okay. So I think we will continue due inquiry quite long in next class. Okay, after the mid break. Okay, so the types of misconduct. Okay, you can also search for additional. There's many cases like now we got cases like producing false MC, false CV. There were two cases or more than two cases, I think, without the qualification as a lawyer, advocate, and solicitor, without the qualification of PhD. Also, there also case on that. Without any qualification that been listed in the CV, your resume, there are case on that also. That means giving false information regarding your qualification. Okay, and then sexual harassment, also misconduct. Okay, and then there's also cases um, that you put in social media. Okay, your activity, indecent activity also. Okay, so I think you can browse through the online library website to have more cases on different types of misconduct at workplace. Okay, okay, students.
Okay, madam.
So any question?
No, madam.
You all can understand? You all read any articles or not? There's articles on domestic inquiry, on misconduct, a criminal misconduct. Okay, as I told you all, everything that you can search online. It's very easy because you always have your phone with you all. Why not search cases and also article on employment to increase your knowledge? Okay. So any other question?
No, madam.
Can we all stop here? Did you all see assignment 2 question?
Yes, madam.
And you already divided or you already given the task among yourself, among the members of the group. Okay, yeah? So I think that's all for the class today. So after the mid break, okay, I'll be seeing you all. Okay, thank you.
Thank you, madam.
Yeah,
Thank you, madam.
Yeah. So it's like still COVID